In this video, we're going to be talking about an incredibly important development that happened last week. The United States Department of Justice has taken a pro-Second Amendment position. This is something that I believe is unprecedented. They filed an amicus curiae brief, effectively a friend of the court brief, with the United States Supreme Court, asking the United States Supreme Court to grant review in a case called Wooliford v. Lopez. This is a challenge to Hawaii's restrictions preventing a law-abiding CCW holder from going to a location that they deem now to be a sensitive location. So after the Bruin decision, there were a number of legislatures, Hawaii, California, New York, and New Jersey, that said, okay, fine, we recognize that the holding in Bruin requires us to give CCWs to people that are law-abiding and apply for a concealed weapons permit. But we are going to effectively make it impossible for them to be able to actually exercise their Second Amendment right to bear arms by creating a novel idea that all of these locations that people normally go to on a day-to-day basis now fall within the rubric of being a sensitive location where we can prevent the carriage of weapons. So they, in the past, and as articulated in Bruin, a sensitive location is some place that is likely to have a highly inflamed passions, and that there is some level of governmental protection that is afforded to the individuals that are at that location. So an example would be a courthouse. In a courthouse, there is a high likelihood that there will be inflamed passions. After all, in any court case, there's going to be a losing litigant. To make things even better, the United States government or the state and local governments go to the extra effort of ensuring that there are armed personnel at that location to protect the unarmed individuals that are there to handle their cases and controversies. Okay, guys, I'm going to pause this video for just a second. USCCA, which sponsors these videos, they're doing a giveaway right now, and it's really cool, but it does end fairly soon. So you're going to want to get on it right away. You can read all about it in the link directly below this video in the description. But like I said, time is of the essence. You're going to want to click on that. Okay, with that, let's get back to the video. All right, makes logical sense. Well, Hawaii said, well, you know what? We can expand the concept of a sensitive location to include a playground or a museum or a library or any private place of business that has opened up their business for public use. If the business owner does not proactively invite CCW holders onto their property, it will be presumed that they don't want CCW holders coming onto their property. And effectively, this law that Hawaii promulgated gave business owners two methodologies to allow people to come onto their property while carrying guns. One methodology would be through the use of a sign, something welcoming CCW holders in. The other possibility is some sort of a verbal communication. If a business owner were to simply invite an individual to come on in and said, please, by all means, bring your firearm with you. Both seem to be obviously somewhat problematic. Effectively, it is a means of compelled speech. After all, a business owner, it will be or should be construed, is going to allow people into their business that are engaged in lawful conduct. This seems to be, obviously and transparent. But if an individual business owner doesn't want individuals coming onto their property, they have to announce that they don't want someone to come in. There's a long historical tradition of this. All right, well, California They also had a response to Bruin, which was a little bit more draconian. There's what we call the vampire rule, where the business owner had to proactively invite someone in. That could only be communicated with a state mandated sign. If you were a business owner in California and you saw a friend of yours that you happened to know was a CCW holder, and you said, "Hey, Bob, come into my shop, have a cup of coffee," and you did not have that state mandated sign on your door welcoming CCW holders in, if Bob were to come into your business, even though you had proactively verbally invited him, that would not be sufficient under the eyes of the state as being an affirmative request that the individual come in with a gun. It's absolute nonsense. Hawaii's, like I said, was a little less restrictive. You could do it by having the sign, or you could do it verbally. Well, both cases, Williford v. Lopez, which challenged the Hawaii's restriction, as well as May v. Bonta, which challenged the California restriction, both got joined together, went before the Ninth Circuit Court of Appeals, and a 3-judge panel in the Ninth Circuit Court of Appeals said, yeah, California's is in fact too restrictive, and they essentially said it's unconstitutional. On the other hand, Hawaii's, because there has a little bit more flexibility, that one is perfectly acceptable. Well, now the U.S. Department of Justice has weighed in. They've said to the Supreme Court of the United States, this is utter garbage. You need to take this case and you need to overturn the Ninth Circuit's rationale. And in their brief, they take the Ninth Circuit to task, not because of the outcome that was generated by the 3-judge panel at the Ninth Circuit, rather because of the reasoning that the 3-judge panel used. And they're pretty aggressive, to be quite honest with you, in their amicus curiae brief. Now, this holds a lot of weight. The United States Supreme Court is by no means mandated to take a case simply because the U.S. Department of Justice wants them to do so. But the fact that the U.S. Department of Justice does want them to do so is going to most likely tip the scales. Now, this will have broad-reaching consequences. It will, if the Supreme Court decides to hear the case, and if they come to the kind of outcome that we would like them to come to, it would essentially invalidate most sensitive locations. It would also return us to a basic principle that is more consistent with what Bruin had articulated, that at the time of the framing, when we ratified the Constitution and the Second Amendment, it was generally understood that people had the right both to keep firearms in their home for protection, as well as to bear weapons outside of their home for the purposes of defending themselves against confrontation. This is what these anti-gun state legislatures seek to remove, and this would be an opportunity for the Supreme Court to essentially put them in their place. We hope that the Supreme Court decides to take up this matter. If you have any questions for me at all, by all means, go ahead and email me at stephen@artemishq.com. I try to respond to all of my emails. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.